Another frequently asked question here at our law firm is, how are bicycle accidents different than automobile accidents? Or, how is it different if someone's injured when they're on a bicycle struck by a motor vehicle versus if they're in a vehicle struck by another motor vehicle? The answer is that Florida law considers a bicyclist the same as a pedestrian. In fact, it even considers a person occupying a moped the same as a pedestrian. There's actually a size of the engine outlined in Florida statutes, and it says once the engine size gets over a certain amount, it's considered a motorcycle. But until then, it's just a bicycle. And as a bicycle, you're considered a pedestrian. And what that means is you're entitled to all of the laws that protect pedestrians. That means that as a bicyclist, you're entitled to all of your medical bills to be paid by the at-fault driver's insurance company if you do not own your own car. Even if you're on a bicycle, if you own your own car, your own PIP insurance pays your medical bills. But most importantly, if you're on a bicycle, a motorist has a duty to yield the right-of-way to you. There's a statute that says it's presumed that a motorcycle or a bicyclist or a pedestrian have the right-of-way, and that a vehicle, unless a motorcycle or unless a pedestrian or a bicyclist just pops out in front of them unannounced for no reason, they have to yield the right-of-way to you. There are many bicycle accidents in Florida, and most of the time those accidents are not investigated properly. If you're on a bicycle and you're struck by a motor vehicle, do not count on the law enforcement agency that's investigating your accident to properly investigate, to document the case, to take proper measurements. Bicycle accidents involve significant injuries. You need to have a lawyer involved in the case immediately so that an accident reconstruction expert can be hired. Those things cannot be done 3-4 weeks down the road. They need to be done right away.